You're watching the legal breakdown. So, Glenn, we've got an unprecedented move here by Judge Chutkan regarding Trump's claims of presidential immunity in his criminal trial in D.C. Can you explain what she said here?
Brian, unprecedented is exactly the right word. This is the first time a federal court, any federal judge, has ever been asked to rule whether a president has absolute immunity from ever being prosecuted for crimes he committed while president. And in a 48-page ruling that, frankly, is beautifully written, and I usually don't say that, legal opinions are generally a pretty good cure for insomnia. This one is beautifully written. Judge Chutkan surveys all of the historical precedent. She goes back to the intent of the framers of the Constitution. She quotes George Washington at length, and she concludes that a president does not have immunity from being prosecuted for his crimes. It is unprecedented. It's the first legal opinion we have of its kind. And then the next question is, of course, where do we go from here?
Well, there you go. I mean, what does this mean practically speaking? How will this impact Donald Trump's trial in Washington, D.C.?
Yeah, so the reason this issue got litigated now and Judge Chutkan issued her ruling now is because ordinarily, when you are a criminal defendant, you can't appeal anything until your trial has been conducted, you have been convicted, and you have been sentenced. That is when your appellate rights come into existence. There's one exception to that rule. If there is a motion that the defendant could make that, if successful, would end the case right here and right now, would result in the indictment being thrown out, it is this kind of an issue. It's an issue with respect to whether the person who has been indicted has immunity against prosecution. Because think about it logically. If the person has immunity against being prosecuted, then that person shouldn't be forced to go through a trial and a verdict and a sentencing hearing and possibly imprisoned before the issue of whether the person had immunity against prosecution in the first place gets resolved. So now that it's been resolved by Judge Chutkan, by the trial court judge, Donald Trump will have a right to appeal it, and he will undoubtedly appeal it to the D.C. Federal Circuit Court of Appeals. I will put my full buck, Brian. I'm not a betting man, not a high roller. $1 is my betting limit. I would put the full buck on the appellate court affirming Judge Chutkan's ruling, that is, denying Donald Trump's claim that he's absolutely immune from prosecution. Then really the biggest question that we can't yet answer is, will the Supreme Court be interested in this issue? Donald Trump will undoubtedly try to appeal it up to the Supreme Court, more precisely, ask the Supreme Court to review it. And again, I'm thinking the Supreme Court is not inclined to accept review of this issue, which will mean the March 4 trial date will hold and the jury selection will begin on March 4th.
Okay. And now, what defenses does Donald Trump have now that he won't be able to pretend that he had some, magical force field protecting him from prosecution just because he was president?
Yeah, so it's interesting. The immunity claim that he raised, which has now been rejected, really isn't a defense to the crimes. In fact, Judge Chutkan makes the point that Donald Trump is not seeking to have an opportunity to defend against the offenses, the crimes that have been charged against him. He just wants a pass for them. And she said, guess what? We left that system of government behind when we founded our democracy. Presidents are not kings, and Donald Trump will stand trial for his crimes. What kind of a defense does he have? Really, it's what I would call the reasonable doubt defense. When defendants really don't have a strong case on the facts, and they really don't have a strong case on the law, they go with reasonable doubt. What does that look like? What they try to do is attack the credibility of every witness. They try to attack the credibility and the persuasiveness of every document, every piece of evidence, every record that is offered by the prosecutors to the jury to prove the defendant's guilt. And then at the end of the day, they say to the jury, ladies and gentlemen, there's just so much confusion. There's so much uncertainty here that you should have a reasonable doubt about Donald Trump's guilt. That can be a viable defense. It can often be a winning defense if the government's case is not strong. But here, the prosecutor's case is extraordinarily strong. So at the end of the day, I don't believe Donald Trump has any winning defense to offer the jury. And I think he's going to be convicted by that jury so fast, it's going to make his head spin.
I would agree, but to your exact point, I actually think that would be a very appropriate, comfortable defense for Donald Trump, because that's what he and Republicans do anyway. That's very much of this Steve Bannon model of just throwing shit against the wall and kind of muddying all the waters anyway, and kind of casting doubt on the reality of everything, so that at the end of the day, people don't know what's real, what's fake, what's true, what's not. And so, I think that this really, this is actually would be very convenient for Donald Trump.
Yeah, that's a great point, Brian. It's playing to Donald Trump's strong suit, right? Just deny everything, right? Just attack, attack, attack. Here's the thing. The rules of evidence have something of an anti throw all the shit against the wall and see what sticks rule, okay? I'm taking liberties. That's not actually a rule of evidence. But the point is, once these cases move into court proper, the rules of evidence govern. So here's what will happen. Every single thing that's ever come out of Donald Trump's mouth that incriminates him, the rules of evidence say that's admissible as a statement of a party opponent, and Jack Smith will admit it into evidence to prove his guilt. Everything that has ever come out of Donald Trump's mouth that is nonsense, that is BS, that's a bunch of lies and deflection and projection, guess what? It's not admissible. Donald Trump, the defendant, has absolutely no right under the rules of evidence to put any of that stuff before the jury, unless, here's the only way he can do it, he can take the stand and he can spew out whatever he wants, and then Jack Smith's prosecutors will cross-examine him and will figuratively disembowel him on the witness stand. I've seen it happen before. I have cross-examined RICO defendants before. It never ends well for a testifying defendant who's a great big liar like Donald Trump is.
Which explains why, by the way, he's trying to try this trial in the court of public opinion and not in the actual courtroom, because in the court of public opinion, there are no rules to govern what he can and can't say and how much bullshit he can and can't spew. And so that's why, he'll go to these trials and do whatever needs to be perform the perfunctory actions that needs to be performed inside of the courtroom, but then beelines to the camera so that he can spew whatever bullshit he wants to spew. Glenn, if this defense that Trump was holding prior does hold up, that Trump had blanket immunity because of his role as president, wouldn't that basically just mean that Trump thinks he had carte blanche to commit any crime, that he could actually shoot someone on Fifth Avenue, and that it would be covered by this catch-all concept of presidential immunity?
Brian, you're exactly right. That would be the world's worst precedent to set. If a president could commit any crime while in office, sort of content in the understanding, in the knowledge that he can never be held accountable for his crime, what would an aspiring dictator do? Line up his political opponents and imprison them or worse. Right. So, let me just do this. I don't want to bore the viewers, but let me read just 3 sentences of what Judge Chutkan said to reinforce that point that you just raised. First of all, she said, by definition, the president's duty to take care that the laws be faithfully executed does not grant special latitude to violate them, which is what Donald Trump was seeking. She then went on to say, the possibility of future criminal liability might encourage the kind of sober reflection that would reinforce rather than defeat important constitutional values. If the specter of subsequent prosecution encourages a sitting president to reconsider before deciding to act with criminal intent, that is a benefit, not a defect. And let me finish with this sentence. Every president will face difficult decisions. Whether to intentionally commit a federal crime should not be one of them. Like I say, this legal opinion sings, and I recommend that everybody read it. This will be an important document, an important piece of legal analysis and writing in our nation's history.
Great. And I'll include the link to that opinion in the post description of this video. So for anybody who wants to check that out, definitely make sure to check out the post description. Glenn, let's finish off with this. Are we still on track, as far as you can tell, for a March start date in 2024?
We are. Really, the only thing that could now derail that March 4 trial date is if the Supreme Court decides to accept review, accept an appeal, and try to revisit Judge Chutkan's decision that a president is not absolutely immune against prosecution. If they do that, they could, one, decide the issue promptly, like within 30 days, and therefore the March 4 trial date would remain in effect. Or they could say, we need more time. We need 6 months to debate this before we're comfortable, authoring an opinion, deciding whether a president should enjoy some immunity against criminal prosecution. That would derail the March 4 trial date. That could have the kind of cascading effect of pushing the other trial dates in Donald Trump's other criminal cases farther down the road. I don't think the Supreme Court will do that, because I've said all along that the Supreme Court has not shown an appetite to help install Donald Trump into the Oval Office for a second term, aspiring dictator that he is, because had they wanted to do that, they could have done it in the election challenge arena. I think they're going to let this one ride, and I think Donald Trump is going to trial in early March.
Okay, well, obviously a lot to stay on top of here, but good news at the very least with this decision by Judge Chutkan. So for anybody watching, if you want to follow along with this stuff as it continues to progress, please make sure to subscribe. The links are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.